Defense analyst Abhijit Iyer-Mitra is at the center of yet another controversy. After an unconditional apology to the Odisha Assembly about his remarks on the Konark temple, which he made during a video which he posted on Twitter, Mitra was arrested by the police yet again, this time for a series of tweets published a year ago. Authorities claim the tweets hurt the sentiments of the people of Odisha and were derogatory to the state. Now here it's important to say that a lot of tweets put out by Mr. Mitra are offensive. His Twitter account is no longer active, but what he has been saying so far has been designed to shock. Some are frankly downright revolting. But even so, is it in the realm of a punishable offense? Should it be, really? To speak more on this, I'm joined now by Satyajit Sarna, advocate in the Delhi High Court, and Sarvjeet Singh, Executive Director at the Center for Communication Governance at National Law University. Welcome to both of you, and thank you for speaking with us here at Bloomberg Quint. Mr. Sarna, just on the current range of tweets, and here we are making it a point not to show these, because we don't want to shock and offend people. But it's essentially a sort of a repartee between two sides saying West Bengal is better and Odisha is better. Some of it is borderline. But should he be going to jail again after he has apologized once?
Thank you, Tamanna. I think there's a couple of levels to this question. One, I've been through the tweets myself from what I could find online, and it's clear that what happened was a set of back and forths between somebody from West Bengal and somebody from Orissa regarding commonly held cultural symbols and who they originated with. So I believe the more humorous example is that of the Rasagolla. Now, I think it's really important to look at this in context, because he has been arrested while exiting the assembly where he had tendered his apology before the House on the basis of these tweets, which are more than a year old. Now, there is one question on substance. Is this in any way illegal? And the first thing I would say is no, it does not, even as it stands, offend the law in 295 or 153, which are the sections that he's being allegedly brought in under. Second, I mean, we have to have a sense of what the law is there for, and it's there for serious offenses, and that the hate speech laws of India are designed to prevent words from turning into riots. What they're not meant to do is take tweets from a year ago and target a man who has already clearly angered somebody important. At another level, of course, one thing I'm very concerned about is the procedural mishandling of this matter. There is no reason to arrest a person who is willing to come and cooperate with an investigation, especially in a matter which is not a matter involving physical harm. This is not somebody who is either going to run away. This is not somebody who has assaulted physically anybody. This is somebody who has undertaken before the court to cooperate with investigation. This is a man who, knowing he is in trouble in Orissa, has gone to Orissa to right what are putatively wrongs. There is absolutely no ground to arrest this person. So my only question is, who is asking the police to chase this man down and hound him?
No, so they are doing this on the basis of a complaint they've received. A copy of that complaint is with us, and in that 4 specific tweets are mentioned, and they are part of the larger narrative of Odisha versus West Bengal, which, as you rightly said, starts with something about a Rasgolla. It ends, of course, with Abhijit Iyer-Mitra saying some shocking things. But the question I want to ask you, Sarvjeet Singh, is where do you draw the line? Because Abhijit Iyer-Mitra has, in different contexts, talked about machine gunning people he doesn't agree with. He's talked about throwing those he doesn't agree with in jail. Now he can turn around and say that I didn't really mean it, and the fact is a lot of people say a lot of things on Twitter. But then what happens to the law which says that you can't say things that would incite violence?
Tamanna, so I guess we just, as I think Satyajit mentioned, one thing is just to see all of these tweets in context. And while they may be offending, they may be deeply disturbing, one thing which we need to be very clear, and I think our Supreme Court from 50 years back had said, and I thought I'll just first say that, the court had said that the right to freedom of expression includes the right to offend, the right to shock, and to disturb. Now, that is the leeway that the Supreme Court of India gives in context of free speech. While we may not agree with what Abhijit Iyer says generally, a lot of people will not agree with what his ideology is, but arresting him for these things, or even, I guess, the tweets that you have mentioned, I would say even in those, in most contexts, they would not fall foul of the current Indian law.
In that case, then, Mr. Sarna, what can be done now? Because, you know, as it stands and in the purview of the law right now, Abhijit Iyer-Mitra is in custody, his lawyers trying to get him out, these things take time. So he is already suffering the consequences of the legal system, isn't it? And is this sending a broader message to others about being careful about what you say?
Certainly. At one level, what is happening in Orissa right now, I believe, is that the courts are being moved for bail, and there's to be a hearing either today or tomorrow about whether there's to be judicial custody, some amount of police custody for questioning, which I can't understand why, because all the matters that have to be determined are already in public domain. They were tweeted. And beyond that, whether he should be enlarged on bail. To my mind, this is a classic example of where something at worst, where someone ought to be summoned and asked to explain. So arresting was never an option within the law. The other thing is the court has, as Mr. Sarvjeet Singh pointed out, very specifically on the questions of 295A and 153A, held many years ago that the action has to be deliberate and malicious. Not everything that is said that is offensive can be said to be designed to breach the law in that sense. Second, the larger question you're asking, Tamanna, is what kind of message does this send? And the answer is, it is absolutely a warning to everyone to watch what they're saying. And this is what they call the chilling effect on the freedom of speech. In a general context, over the last few years, at least I have been seeing in practice is a large jump in the number of defamation cases which are being filed, both civil and criminal. The Supreme Court upheld the constitutionality of criminal defamation a few years ago, and I would say it did nobody any favors, because sections like 295A and 153A, under which Abhijit Iyer-Mitra is being allegedly prosecuted, and the criminal defamation sections of 499, 500 appear to be weapons in the hands of the powerful. It is hard enough for anyone who wants actual justice, who is powerless, to get the police to even register an FIR. And yet here we have a police leaving one state, going to the state of Delhi to arrest a man over the tweet. So the question appears to also be one of political motivation and misuse of power, which is why I feel that the Supreme Court needs urgently to review the ambit of 295A, 153A, 499, 500, and differentiate or draw out what would constitute bona fide uses of these laws from mala fide abuses, and lay in black and white what those guidelines should be.
Absolutely. The political context is an important point, because Orissa goes to polls with, you know, the general elections in a simultaneous poll. So it's not very far away. There may be an attempt to invoke the pride in the state. Mr. Singh, just to argue from the other point of view, people in this country are very touchy and emotional about their state, about their religious symbols. Some of those have been mentioned in this tweet about their temples. Why should the state not move to protect the sentiments of its people? What if it is argued that way?
I guess what you're saying, that part is correct, Tamanna, but if we look at it from a rights perspective, and I think that is the question here, again, we need to make sure that just because of the majority or what we call the heckler's veto, that is not used to suppress speech of individuals who do not agree with the majority. Again, in terms of 295A, as Mr. Sarna mentioned, the court has said that it has to be deliberate, it has to be malicious. And under 295A, the court has specifically distinguished it from 298 and said that the outraging word that has been used is a much stronger word than just wounding their feelings. So we need to also understand that the sections under which Abhijit has been charged under, they have a very high threshold, which in these instances, again, they might be offensive, they might be tasteless, but that is not something under which you can arrest him or suppress his speech.
All right. The discussion, of course, continues. It's important to note that a lot of people who today, even online, are supporting Abhijit Iyer-Mitra's right to say offensive things, which many don't agree with, which are sometimes disturbing, still say that he shouldn't be put behind bars for saying them. I think that is another point which is at the heart of this discussion. Thank you so much, Satyajit Sarna and Sarvjeet Singh, for joining us today.